Yes. Good morning, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we all gathered here for one of the important topics on anti-defection laws in the leading cases exam for the upcoming AOR examination. We have the honor to have with us today Senior Advocate Amit Anand Tiwari, sir. We welcome you, sir, and we are thankful to you for taking out time. We're showcasing live on YouTube. If anybody has any questions, the same may be put in the chat box and the same will be taken up in the end by sir. I'll start with the introducing sir. Amit Anand.
Meenakshi, you're not audible.
Clear the advocate on recording. Am I audible, sir?
Please repeat. We were not audible at that time. I think there's some network issue.
Sir, I'll just start again. Amit Anand, sir, was a senior advocate designated by the Honorable Supreme Court of India and is currently serving as the Additional Advocate General for State of Tamil Nadu. He's been practicing before the Honorable Supreme Court for 24 years. With his practice areas including constitutional law, election law, civil law, and criminal law and commercial law. He cleared the AOR examination in 2007 and was in AOR for around 17 years before his designation. In the past, he's held several key positions, such as the Deputy Advocate General for State of Uttarakhand, Special Counsel for CBI in the landmark coal scam case, Special Counsel for Directorate of Enforcement, Counsel for the Honorable Supreme Court of India and the Central Information Commission, among others. He's appeared in numerous high-profile cases of constitutional significance and public importance, including the Abu Salim extradition case, Telgi scam case, DDA scam cases, Justice P.D. Dinkaran's impeachment case, presidential reference in the year 2002 in Gujarat election matter, privileged proceedings, NCP, AID, Shiv Sena disqualification, and symbol disputes. There are various other cases that sir has appeared in landmark cases. He has an extensive experience of conducting election disputes and has represented various national political parties before the Honorable Supreme Court of India, Honorable High Court, and the Honorable Election Commission of India. In disputes relating to party symbols, split in political party, disqualification due to defection, etc. He's also represented a wide range of clients, including corporations, educational institutions, public sector undertakings, and government ministries across forums. Thank you, sir, for coming on board for the AOR lecture series. I now request you to please start with the lecture.
Thank you for giving me this opportunity to speak and give my views on these leading cases. So, first of all, I would say and rather ask a question from everyone: why do we need leading cases? The idea of these leading cases is that they are the critical juncture in development of law on a particular topic of the constitutional significance or social significance. Today's lecture is relating to three cases which are one of the most significant cases in anti-defection law. As we know, 10th schedule. The first judgment of Quixote, which is of 1991, related to the validity of 10th schedule itself. The second case is of Kisham Meghan Chandra of 2020, which brings back to the focus the role of speaker and also the key timid action in a matter relating to 10th schedule. And third judgment, which is another very significant and critical judgment in development of law relating to 10th schedule, is the judgment of the Subhas Desai, which is of 2023. And in this judgment, the question which related was of the impact of 10th schedule on one, what happens on the inside the house, its impact outside the house, its impact on the formation of government. All three questions were examined and deliberated, and the judgment was rendered by the court. Or in other words, it rather holistically examined the impact of anti-defection in cases, impact on the political party dispute and the formation of the government. So first, I was saying why we need leading cases. Leading cases has been relating to how do we look the law at a particular point of time. These leading cases at one point of time may have decided the question in one way, and their impact on those laws, like in the case of Quixote, the issue relating to intervention of the court at an interim stage was said to be prohibited by key-timid action. But later judgments permitted those interim intervention by the court also. So how the law has developed from no key-timid action to actions and interior to the decision being made by the speaker. Why do we need these cases? And the cases will throw light how the law has developed. Now, the second question which comes, how do we read those cases? So, one, we look at the factual situation. Secondly, we look at the contentions by the parties. And thirdly, we look at the reasoning. Mostly it is seen that we look at the reasoning, what is decided by the cases, but they may not be the significant sole reason why we should read a judgment. We should also look at the factual and the factual situation in the judgment and the contentions made by the parties, because it helps us in understanding what law could be. As I was telling you in the Quixote, the court said that no key-timid action. Key-timid action is an action prior to the decision having been taken by the speaker finally on the anti-defection law. But later judgments, the later judgments diluted this principle. Secondly, the court said that the speaker is an authority which should be allowed to perform the function of adjudicating tribunal. But later decision, the arguments which were rejected in the first judgment, the Quixote judgment, were later resounded in Kisam Meghanchand as well as reiterated in the Subhas Desai. So therefore, it is significant when we read judgment, we should look at the contentions of the parties also, because they may be the law in a later judgment. Like we saw that the law basic structure was argued but rejected up till the Golaknath case, but it became main law in the Keshwanand Bharti case. So therefore, it is not only significant to read the reasoning of the judgment, but the contentions and the factual situation. Now, in this backdrop, let's start what is the judgment in the Quixote. So Quixote basically decided the constitutional validity of the 10th schedule. The 10th schedule has a background in which it was enacted. The law till 1985 was that a legislature, a member who has been elected, can freely change his allegiance from one party to another party. The issue of defection has been a political problem which was faced by the democracy since 1960s itself. Considering these problems, in 1967, the parliament formed a committee which was known as Committee on Defections. This committee gave its report in 1969. The Quixote judgment, in fact, notices that what was the finding of that committee's report. It was found that most of there are significant number of member of House who switch their allegiance from one party to another party. It was noticed that this switch of allegiance from one party to the another party was based on monetary consideration, were based on in consideration of getting a position of minister or any other significant position in the government. This led to a deliberation what should be done, how to prevent an unprincipled, unethical switch in allegiance of a elected representative of the House from one party to the another party. The underlying assumption of formulating this issue was that the political parties basically function on a common shared belief of policies, issues, and thoughts. When it was found that a person who has elected on a particular party symbol and has left that party and has joined another party, it really shatters the confidence of the electorate, not only in that person, but also in the party. It was found that people started having lesser belief and faith in the political principles adopted by a particular party. To prevent this unethical defection, finally, by 52nd Amendment, the Constitution was amended and 10th Schedule was introduced. Now, 10th Schedule was put to challenge. This 10th Schedule has three broader principles. One principle in the 10th Schedule was that the persons cannot change their allegiance. They cannot resign from the political party on whose ticket they have been elected and join another political party. So that was the first principle enumerated in the 10th Schedule. The second principle which was enumerated in 10th Schedule was relating to the voting against the party whip. A whip is a command by the party on a command or direction asking the party members to vote in a particular manner. So suppose there is a bill which is presented, a party can issue whip and ask its member to say that you vote against the bill. Now, if a member who votes in favor of the bill will be said to have violated the whip. So second principle which was incorporated in the 10th Schedule was that no one should be allowed to vote against the whip. In case you have voted against the whip without permission of the party, or if the such vote is not condoned within 15 days of the voting by the party, then it was taken as a defection. Then the third principle which was incorporated was relatable to the independent members and nominated members. As far as nominated members are concerned, the bill said, the amendment said that they can join a political party within 6 months period, but thereafter they cannot either join or change the party. As far as independent members were concerned, they were prevented from joining any party after their election as an independent member. So the bill basically strike down these three fundamental actions of an elected representative. The second part of the constitutional amendment related to what are the actions which were saved by that in such situations. So one action which was saved was split in the parties. So 1/3 member of the party, if they split and form a new political party, the amendment protected such 1/3 member from the defection law. The second defense which was incorporated was defense of merger, where if the 2/3 of members of a party agrees to merger of a party from one part and becoming a new party, the constitutional amendment protected such defections also. The third part of the bill related to the adjudicatory process, which was para 6 said that the speaker will be the adjudicator and his decision shall be final. And para 6(2) said that the procedure shall be provided by the rules framed by the speaker in Legislative Assembly. The para 7 of the 10th Schedule provided that in case the decision is taken, the decision shall be final and there was a bar of jurisdiction. No court was permitted to intervene in such decision made by the speaker under the 10th Schedule. the challenge before the Constitutional Court and in Kyoto was that 10th schedule is unconstitutional. The unconstitutionality was made on three basic grounds. The first ground related to non-ratification of the bill. The argument was that the 10th schedule, para 7 of the 10th schedule, in effect takes away the judicial review enshrined under 136, 226, and 227. It was said that in effect it amends the part 4, chapter 5, and therefore it leads to this amendment process requires ratification of more than half of the state under the proviso of Article 368. The second ground of challenge related to the finality attached to the decision making by the speaker. It was said that the finality which is attached to the speaker's decision making is wrong and it cannot be allowed because it again takes away the basic structure of judicial review of any decision making. Third aspect was relating to the basic structure of democracy, where they said that once you make the speaker as the chairman of the speaker as the adjudicating authority, sole adjudicating authority, it strikes at the very root of the basic structure of democracy. The argument was that the speaker, being a partisan person, he is elected on a party ticket as a member of the House, and thereafter his continuance in the position depends on the majority in favor of him being the speaker, because a speaker is elected by the House by a majority vote. So it was said that since his induction in the House and continuance as a speaker itself is dependent on his allegiance to a particular political party, his impartiality cannot be ensured. One, two, it also strikes at the adjudication of a composition of the House, and it leads to basically destroy the basic structure of the democratic constitution of the House. In Kyoto, a majority of 3 judges, Justice Venkatachalaya, Justice Venkatachalaya, Justice Jayachandra Reddy, and Justice S.C. Agrawal, they held in favor of the constitutional validity of the 10th schedule, except for the validity of para 7 of the 10th schedule. They held para 7 to be unconstitutional on the ground that it takes away, if it in effect amends the 136, 226, and 227, and therefore it required ratification from more than half of the states under the proviso of Article 368, Clause 2. But there was a dissenting judgment by Justice J.S. Verma along with L.M. Sharma, who held that the entire 10th schedule is unconstitutional. The minority held that if para 7 is unconstitutional, there is no question of it being severable, because the entire constitutional bill has to go for ratification if it is seeking to amend any part which requires ratification of the more than half of the states. So it said that there is no question of applying the principle of severability, and therefore entire bill goes. And they held the entire bill to be unconstitutional. As far as role of speaker is concerned, the majority judgment in detail held, one, that speaker by tradition and by convention has always been a post having authority and impartiality. So it cannot be doubted, his impartiality and authority cannot be doubted. Then they said that speakers have always been functioning in a very impartial manner, and this post, as per its tradition, has always performed the duty which included judicial functions also, because speaker sometimes gives ruling on a question which is raised in the House as to the issue of whether some person has conducted himself properly or improperly. They said that even by precedent and convention, the speaker has been treated as an impartial position and position of authority, and it has conducted so, and therefore conferment of power on speaker to adjudicate the 10th schedule disputes of defection cannot be said to be violative of basic structure of democracy. On the third issue of the finality to be attached to the decision made under para 6 by the speaker, the court held that these finality clauses have been interpreted by various judgments in past. These finality may be finality on procedural and other aspect, but as far as judicial review on jurisdictional issue of mala fide, issue of acting contrary to the provision is concerned, that cannot be taken away. The court concluded by holding, the majority concluded by holding that one, that is the 10th schedule as enacted by the 52nd Amendment is a valid law except for para 7. It also reaffirmed the impartiality and adjudicatory power of the speaker, and it circumscribed the finality clause attached in para 6. Very interestingly, while circumscribing the power finality clause under para 6, in para 100 of the judgment, the court said that finality clause will only preclude judicial review of the actions of the speaker at a stage anterior to his finally having decided the dispute, unless until his interim orders are such that they completely decide the dispute at the interim stage, such as suspending the members. The court said that unless until an interim order of a final nature is not made, no key timid action will be taken by the courts. Why I am pointing out this specifically? Because the other two judgments dealt with this aspect only, that what would be the key timid action and how key timid action can also be challenged. This significant aspect was relatable to the quicker decision making by the speaker. When 10th schedule was introduced in 1985, in the parliamentary debates, a question was raised: why should the 10th schedule, the speaker be given authority? And there also the question was raised that he will be belonging to a party and his decision may not be impartial. Therefore, such adjudicatory process should be entrusted to the election commission or a agency outside. As all of you might be knowing, that other than the disqualification, question of disqualification of a member under 10th schedule, the other question relating to disqualification of a member in the House is always examined by the election commission, who gives a report, and on his report, the president declares the person disqualified or not disqualified, as whatever is recorded in the report. So there, the earlier process which was existed in Article 191 and 102 were relatable to adjudication of these disputes outside the House. So similar demands were made when the bill was being introduced, the amendment was being introduced, that it should be by the speaker, it should not be by the speaker, but an outside agency. The response to this was that, which in the speeches contained in the then Law Minister, Mr. A.K. Sen, who was also a very renowned senior counsel of the Supreme Court, and by the then Prime Minister, Mr. Rajiv Gandhi, was that we are investing the speaker with the authority for two basic reasons. The first reason cited by them was that the speaker is in know-how. He is in the political thicket. He knows what is happening inside the House, how members are conducting them, because he will be seeing whether they are voting in favor, they are aligning with the other party or not. So they said the first reason, he will be closer to the conduct of the member. second reason cited by them was that the courts or any outside authority in experience have been taking a lot of time in deciding whether the member has fallen foul of a particular provision and therefore rendered himself disqualified or not. They said the time taken by these authorities outside these house, they virtually render the entire provision nugatory. So here the idea is of a quicker, expeditious decision making by the speaker so that the unprincipled defection should not result in any serious consequence, such as fall of the government or formation of a new government. So they said that this will prevent this speedy and expeditious and timely decision making by the speaker would result in preventing any such untoward action. Now, experience have been to the contrary. So I will give, there are three judgments which we are discussing today. First is Quixote, which I am talking. Second is the Kisam Meghanchan. Third is the Subhas Desai. But there has been some more significant judgment in between, such as Utkal Kesari Parida, which provided that even a person who is not member of the house, because most of the assemblies frame the rules that only member of the house can move an application for disqualification of a person. So in Utkal Kesari Parida judgment, the Supreme Court relaxed the rule of locus and said even a party, because what happened in that case, four NCP MLAs defected, four NCP MLA were elected to the Legislative Assembly of Orissa. All four of them defected to Biju Janata Dal. The question arose, there was no one to make complaint. So party president made a complaint, which was rejected by the speaker. The court held that if there is no one who will complain, so therefore the locus was relaxed. That was one significant judgment. In between, the other significant judgments were Jagjit Singh, Rajendra Singh Rana. Jagjit Singh and Rajendra Singh Rana discussed about the key Temet action. They also discussed about how if the speaker is failing to make decision, what is the action which can be taken by the courts in judicial review. In fact, in Jagjit Singh Rana, which is 2007 judgment, the court went ahead and decided the dispute itself in the Honorable Supreme Court. It said that remanding the matter back, and again, if a speaker fails to decide, it will be difficult. The entire objective will be frustrated. So the court went ahead and exercised the jurisdiction and decided the dispute itself here in the Supreme Court. In that case, what had happened that 13 MLAs of BSP from BSP defected and joined SP. A complaint was made to the speaker because 13 members do not amount to 1/3 of the total number of the BSP MLA returned to the House. That complaint remained pending. In the meantime, 24 more MLAs defected and they joined. Now 13 plus 24 formed together and gave a petition to the speaker to say recognize them as a splinter group of BSP. On this second application, which happened after almost 4 months, the speaker recognized them as the splinter group, saying that total 1/3 number of the members have defected. Therefore, they form a splinter group and they are saved by the para 3, the then para 3 of the 10th schedule. Thereafter, the petition was filed before the High Court. High Court did not decide the dispute, remained pending. The matter was remanded back. Then it was challenged before the Supreme Court. By the time matter was heard by the Supreme Court, around 1 month time was left in the tenure of the assembly. The court, after hearing the matter, held that such kind of non-decision on the first application was unconstitutional. And it said that if first 13 MLA would have been disqualified, the 1/3 could not have been made out, and therefore said that the action relates back to the date of when they first time defected, and said that you cannot by a subsequent conduct save your earlier misconduct. and disqualified all those 37 MLAs. So that was a significant constitutional development in terms of decision making under 10th schedule. Then came the Kishan Meghanchan. In that, the issue related to the time to be taken in deciding a dispute. In fact, about a key Temet action, there was a reference to a constitution bench of Sampat Kumar case, that whether the court can direct in the interregnum pending adjudication before the speaker, that you decide the disqualification within a given period of time. The arguments raised before in Kishan Meghanchan, what had happened, that 13 MLAs defected. The complaint was filed before the speaker in 2017. Speaker did not decide. The parties approached High Court. High Court in 2019 held that that at a key Temet stage, I cannot interfere. I cannot issue a direction that the speaker should decide the petition within a given time frame. Therefore, the dispute before the court in Kishan Meghanchan was that whether a direction can be issued by the court to decide dispute within a given time frame. The court examined the reference order in Sampat Kumar and Jagjit Singh and other previous judgment and said that non-decision by the speaker is a failure of jurisdiction vested in the speaker. A constitutional duty, when is entrusted on a person, she cannot, by not deciding the matter, fail in that performing that constitutional duty. And Kishan Meghanchan therefore held that the speaker must decide and a dispute when presented, and it prescribed a time limit of 3 months for making decision in those disqualification petition. Now, this raised a significant departure. This was a significant departure from the judgment of Quixote, where the court said that when a speaker is deciding as a tribunal and when there is a finality attached, a writ of certiorari cannot lie if he is acting within the jurisdiction. So therefore, the argument was that if he is not deciding, it is also within the jurisdiction of the speaker. To decide or not to decide is within the speaker, and therefore direction to decide within a given time frame may be not within the framework of the constitution. The second issue which was raised in Kishan Meghanchan was the role and impartiality role of the speaker in the decision making. In Quixote, when the argument of impartiality of the speaker was raised, it was by the majority, it was rejected. But the minority accepted the argument and said that it would amount to the speaker entering into political thicket. And it will be difficult to hold that they will remain impartial. And this came true, as was evident from the subsequent decision makings by the speaker in these defection cases. In fact, if we look at generally the data available in the public domain, so far there are 70 cases which have been decided on and reported. There are 70 reported judgments which are available on these defection issues. Defection could be of 3 types. One, when a person defects from a party in power to a party opposition party. In such cases, if the speaker belongs to the party in power and remains in the position of chair, the disputes are decided within a week. In fact, in some cases, the dispute has been decided as expeditiously as 36 hours. Recently, in Himachal Pradesh defection case, the decision was taken within 36 hours of the defection. But when defection takes place from opposition to the party in power, the disputes have remained pending for years altogether. As I was pointing out that Rajendra Singh Rana case, where the defection was from BSP to SP, which was in power. So dispute was not decided for 5 years. And this is the standard case in almost all cases relating to the defection of the members of the political party. So considering all these aspects in Kisan Meghanchan, now the court discussed that this is a high time when we should decide whether a speaker should continue to be the adjudicating authority. This leads to one more significant problem, which is political and in parliamentary democracy is also undermining the authority of the speaker. A speaker, by tradition and is by long-standing tradition, has always been treated as a person of authority and impartiality. They have to perform a lot of function inside the house, including the conducting the affairs of the house, including the privileges motion, how subjects will be allotted, what committee, which member will be allotted, which member will be allowed to speak, which member will not be allowed to speak. So generally, day-to-day affair of the parliament is conducted by the speaker, or the house is conducted by the speaker. So when disqualification adjudicatory process was entrusted to the speaker, the people have started lowering their trust in the speaker's authority. They started thinking that the speaker is completely partisan person. Because when they are deciding, and as I pointed out that in cases the defection, when the person are defected from the party to which a speaker belongs to another party, the decision is generally rendered within a week. On the contrary, when the person defects from the party to which a speaker belongs, it takes years. So the trust and the faith in the institution itself was diminishing. Which led to observation which are made in Kisham Meghanchan about the impartiality and the role and the time that whether a speaker should continue as a authority to decide these political disputes or not was decided in Kisham Meghanchan. Therefore, in that sense, the Kisham Meghanchan is a significant turn of event in the anti-defection law. One, that it really prescribes the constitutional time limit. Two, it also questions the impartial conduct of the speaker, and rather in a very strongly it recommends that the speaker should no longer be continued as a adjudicating authority under the 10th schedule. In fact, Kisham Meghanchan has also been significant in terms of laying down the principle, or rather reaffirming the principle, that when there is a constitutional duty entrusted on a constitutional functionary, it is expected that that constitutional functionary will perform the said duty within a reasonable period of time. The extension of this principle we have recently seen in the Tamil Nadu governor case, where the court has prescribed the time limits for the governor to either give assent to the bills, both to the governor and the president, to either to give assent to the bills, and the entire time frame how the bills will be once presented will be dealt by the both governor and the president. Therefore, in that sense, the Kisham Meghanchan opens up a new jurisprudential path in terms of providing a time frame for the constitutional functionary to perform their important constitutional function. This brings us to the third judgment, which is the Subhas Desai judgment. Now, in Subhas Desai, the boundaries of 10th schedule were pushed further. Subhas Desai was a case where the dispute unfolded on three fronts. One, it was a dispute relatable to the defection of the members from one party to another party. That was the first dispute under the 10th schedule. Then the second significant portion of dispute related to the governor's role in inviting a party to form, to prove its majority and to form government when the party is suffering from defection and the other party is being benefited from defection. The third aspect which was dealt in the Subhas Desai judgment related to the dispute intra-party. Because if a member of a political party defects from one party to another party, it definitely leads to intra-party disputes as well. So up till the extent of Subhas Desai, the judgments have dealt only with the 10th schedule and never delve into the intra-party dispute, which is popularly known as symbol dispute. But the Subhas Desai was the first case where the court dealt with that aspect also. The reason for dealing with that aspect was because the dispute decided by the symbol dispute, which was decided by the Election Commission, was on the ground that the one faction of the Shiv Sena, the Sindhe faction, which was formed by defection, has majority in the House. The question, therefore, before the court was that if the defection is found to be unconstitutional, all these members who have been said to be forming the majority in the Sindhe group will be disqualified, and therefore they cannot be held to be the party, because this majority was the sole ground for holding that they were the party. Before I proceed further on Subhas Desai, I would like to give a little background on what is the symbol dispute. The political parties are recognized by the Election Commission of India. The political parties are basically of three natures. One, that registered political parties, which are recognized as national parties. These parties have to secure a certain percentage of vote and certain percentage number of seats in order to gain the status of a national party. Benefit of being a national party is that you get a common symbol throughout the country wherever you contest the election, like BJP, Congress, Aam Aadmi Party, CPI, CPM. They are the national BSP. They are the national parties. They get a common symbol wherever they contest. Then the second type of political parties which are recognized by the Election Commission of India are the state parties. They are the parties recognized in a particular state, like Samajwadi Party, like RJD or DMK, AIADMK. These are the state parties. They get a common symbol for all its candidates throughout the state, but outside the state, they may not get the similar symbol. They may be preferred in allotment, but they may not get. Then the third type of parties are registered unrecognized political party. All these type of registration is provided under this Symbol Reservation and Allotment Order 1968, which also prescribes for what happens in a case of intra-party dispute. Basically, there are two types of intra-party disputes which are recognized under the symbols order. One where the part of the party member is split and form a new political party or whatever, that is para 15. And the second type of disputes recognized under symbol order is under para 16, which deals with the merger of political party. Now, in Subhas Desai, when Sindhe group, the Shiv Sena, there was a split in Shiv Sena. The split by 91st Amendment to the Constitution from 1/1/2004 was deleted as a defense to any defection. So if there is a split in a political party and two factions are created, earlier, prior to 1/1/2004, it was a defense, and no member could be disqualified if the defected group forms 1/3 of the of the members in the House. But after 1/1/2004, this after deletion of para 3, defection, the split is no more of defense for defection. So if you form a splinter group, the members belonging to the splinter group of the political party will automatically stand disqualified by virtue of para 2(1)(a) of the 10th schedule. Now, the splinter group of the Shiv Sena, which is the Shiv Sena Sindhe group, filed a petition before the Election Commission claiming that they are the real Shiv Sena. And the group led by Uddhav Thackeray is not the Shiv Sena. The Election Commission held in favor of the Shinde group, holding that majority. They had the majority. They had almost 2/3 members of the legislative party representing. Shinde had represented them. So they said that they are having the majority. Therefore, they are the real Shiv Sena, and the Uddhav Thackera's group was said to be not the real Shiv Sena. Now, the question before the Supreme Court in Subhas Desai was that till the time disqualification petition is pending before the speaker, because the disqualification petitions were immediately filed in June 2022, seeking disqualification of the members of the Shinde group. Those petitions were pending. How can a party be recognized treating these members belonging to Shinde group as a majority group? So what was required to be decided in the Subhas Desai was, one, what would be the sequence of decision making? Because if first Shiv Sena symbol dispute is decided, then it will have impact on the disqualification also. Because once it is decided that Shinde is the Shiv Sena, the group belonging to the Shinde, the members belonging to the Shinde group will never be disqualified because they are the Shiv Sena. So there is no question of a member belonging to Shiv Sena joining Shinde group as a disqualification. Then the consequence would be that the Thackeray group people will be treated as splinter group and will stand disqualified. Whereas in reality, the people defected from, people switched their allegiance from Uddhav Thackeray to Shinde, and therefore this looked as a natural disqualification. However, once the Election Commission has decided that Shinde is the Shiv Sena, there is no question of disqualification. So this was the question which was posed before the court, that what should be the sequence? Because there cannot be a sequence which will be giving an unintended result in 10th schedule. The second question was that how can a post-poll splinter group go and claim that they are the Shiv Sena and they should be sworn in as the government? And on their representation, can a properly elected government be called upon to show the majority? The third question which related was that once you hold that the one party is the Shiv Sena or the not the Shiv Sena, how to deal with what the speaker will do, how a speaker will decide which one, who has defected from which faction to another faction. So this was the third dispute. Now court dealt with all these three aspects and said that it is difficult to provide a constitutional sequence of decision making, and it will depend on the exigencies of situation. So it said that all the constitutional authorities will be within their right to decide the dispute independently. So a speaker will decide under 10th schedule independent of the decision being made by the Election Commission of India. Election Commission of India will be eligible to decide dispute independent of the decision being made by the speaker. And therefore, this decision on sequencing is difficult. However, court laid down certain guidelines how a speaker will decide. Suppose because the party dispute, symbol dispute usually take longer time. The court said that in the interregnum, if a speaker will have to decide on disqualification, what would be the parameter, how much he will deal with the evidence relating to party dispute and other things. The court said that prima facie they will look at the evidence and decide that which is the original political party and which is the splinter group, and take a decision on this. And based on that, we'll decide whether persons have formed the splinter group or they have defected from one party to the other party. So this was the constitutional issue decided as to the sequencing. As far as governors inviting the party to prove its majority on the floor of the House, the court held the action of the governor to be unconstitutional. The reason for this was that under the Bomai case, it was held that there could be four type of governments, where the government on its own can form the majority, the government in a pre-poll alliance can form a majority, government could in a post-poll alliance can form a majority, government could be formed in between the formation house is when house is in session. So the court said that in this case, one faction of the Shiv Sena cannot go and say that now the other faction is in minority, because this would go against the principle of the one political party, representation of one political party as a unit. And the court said that the governor was wrong in recognizing another faction or intra-party dispute to call for majority to be proven on the floor of the House. The court said that governor cannot enter into the political thicket. It cannot go and look into whether there is a political dispute. There are two splinter groups in the Shiv Sena. It could not have. And the session of the House, when it is not in session, it cannot call the party to prove its majority on the floor of the House. However, it did not give the ultimate relief to the Uddhav Thackeray group on the ground that Uddhav Thackeray, when he was called to prove his majority, resigned and said that though we find that action of the governor in calling the Thackeray group to prove its majority on the floor of House as unconstitutional, we cannot grant any relief. The second aspect of calling the Shinde to prove the majority and form government, the court held that once the Shinde has resigned, governor, if a person goes to the governor and says that I have the majority and I can prove my majority on the floor of the House, there is nothing unconstitutional in governor calling such person to prove his or her majority on the floor of the House. So the court decided in that action of the governor calling Shinde to form government is a correct decision. So now we have seen from Quixote's position, where before I go on that, one very interesting factor that subsequently the speaker decided the disqualification matter in the Shiv Sena dispute and held none of the faction to be disqualified, which according to me may not be the correct position in law, because either one group should be disqualified. If there are two factions exist, the split not being a defense, one group must be disqualified. If the Shinde is the real faction, then the Thackeray group must be disqualified. However, the speaker has not decided and said that both the groups are not disqualified. It may be noted that both the groups have filed disqualification petitions against each other, but the speaker refused to disqualify any party. In fact, the members belonging to the Shinde group also continued in the assembly till its life came to an end, as well as the members belonging to the Uddhav Thackeray group also remained to perform their functions as elected legislature till the assembly life came to an end. So this was a very interesting outcome in the Subhash Desai, where the dispute was decided, but in effect, no effective result was achieved. So we see from Quixote till Subhash Desai judgment, the courts have come a long way, where they have recognized that while letter of the law may be such which confers authority and presume impartiality on a particular constitutional authority, but in practical experience, they may not live up to the letter of law and spirit, and therefore the judicial intervention will be essential. And secondly, the court has also realized that today the persons who are manning these constitutional institutions are not actually performing their duties within the constitutional spirit or the manner in which they ought to perform their duties and the way convention expected them to perform their duties, and therefore intervened, now has been intervening on a more proactive basis, perhaps, which some people say that call it too much of judicial activism, but in reality, such intervention do uphold the spirit of the constitution and make the functioning a better rule of law, and ensures that the provisions of the constitution not only performed in letter but also in spirit. So if you have any other question, I can answer that.
Enlightening. There's only one question that has been asked. I'll just repeat the question. So Abhinav Verma has asked that kindly explain the Nabam Ribia case. I would also like to understand its significance and how it relates to our impacts in the Subhash Desai case.
Yes. So in Subhash Desai, what happened in Nabam Rabia, the Supreme Court said that a speaker cannot deal with a disqualification issue or altering the composition of the House, and would be precluded from deciding a disqualification petition. So if there is a motion is made against for the removal of the speaker, then the speaker cannot decide on the disqualification petition, because decision on such disqualification would result in altering the composition of the House. Now, this was the issue raised even in the Subhash Desai. What happened, that parties moved before the speaker that he should, no confidence motion was moved against the speaker appointed by the Sinde group. So the question was whether a speaker can decide the question of disqualification. The issue raised before the Supreme Court was that how Nabam Rabia would apply to the facts of this case. The court said that there cannot be a constitutional hiatus and doubted the correctness of the decision made in the Nabam Rabia, that in the event there is a motion of removal of a speaker is pending, he cannot deal with the disqualification petition. So in that context, firstly, the Nabam Rabia question was raised before the regular bench, which was 3-judge bench in Subhash Desai. The question, when was considered by the 5-judge bench, it referred to a larger bench, finding its disagreement with the reasoning given by the Nabam Rabia, that in case a motion to remove a speaker is pending, then he cannot deal with the disqualification petition.
He's asked that did quiet time action have any bearing on the Subhash Desai case?
I couldn't hear.
Meenakshi, you're not audible.
So
I
sorry.
couldn't hear.
Am I audible now, sir? Am I audible?
Your voice is breaking, Meenakshi.
So the next question has been asked by Abhimanyu Yadav.
Please tell me.
Am I audible now? Am I
Meenakshi,
audible now?
no,
sir?
Meenakshi, I think there's some connectivity issue. Just check, please.
Right, sir. Sir, there's only one more question that is been asked. Did quiet time action have any bearing on the Subhash Desai case?
It had none because now it is even otherwise insignificant. The parties approached court. In fact, it was argued when the notices were issued in the Subhas Desai case and the parties were allowed to file their reply in June 2022. I think 26th or 27th June 2022. The question was raised before the court when a disqualification petition was moved against the people who have defected from Uddhav Thackeray group to Shinde group. Shinde group filed a petition before Supreme Court and said that only 2 days time has been granted to them to file reply. The court issued notice and extended time to file reply till 12th of July, I believe. I don't remember the exact date. Then the issue was raised that it was a key temate action, which has resulted in fall of a duly elected government of under the leadership of the Uddhav Thackeray. But that key temate argument lost its significance because once time was extended, in the meantime, governor called parties to the Uddhav Thackeray to show his majority in the house on the floor of the house. He resigned. Then Shinde was invited to form the government. Shinde became the chief minister. Then Rahul Narvekar was appointed as the speaker in the house, and then the disqualification petitions were not decided for almost 2 years, a 1.5 year period. So in that sense, key temate action by the court resulted in disqualification petitions not being decided. But court ultimately did not really go into that question. Though there was when the argument was raised that you should dismiss the Shinde government because it was unconstitutional government, this part of the argument was raised that it was court intervention at key temate that which led to this downfall of the democratically elected government. But ultimately, court did not agree. So key temate action in that sense in Subhas Desai had adverse impact on one party, which was the respondent and the then chief minister who had to lose the government ultimately.
So the next question asked is by Priyanshu Sinha. He says that 3 types of defection were explained. First is the party in power to opposition. Second, opposition to party in power. Please explain the third one.
The third is where defection is from one party to the another party, but both of them not in power or real opposition. So it could be like in a multi-party democracy, as we know that now BJP is the main party, Congress is the main opposition. But suppose a defection takes place from an AIADMK member defects to DMK. Now this is insignificant in that sense. It will make no difference to the party in power or opposition gaining the power and becoming the party in power. So these are the third type of defection are those where their real consequence is insignificant on formation or fall of the government. So there the disputes are decided within a normal time of 3-4 months time. They generally decide. There are only few instances. There are 3 or 4 instances out of those 70 odd cases which are reported. So there it has been decided in a normal adjudicatory manner within a normal time frame. Meenakshi?
Meenakshi? Actually, today she's in Saket, so there is some network issue. Meenakshi, not audible.
Sir, we just end with the vote of thanks. Thank you, sir, for being a part of the Supreme Court Advocate Audit for Association AOR lecture series. Heartily glad gratitude to you, sir, for being a part of this lecture. You're illuminating insight on the judgment and the topics will definitely help the AOR students. I wish you a wishes, sir. Thank you.
So on behalf of Advocate on Recordization, I thank you for such a interesting and good lecture, sir. And we hope that next time also you will be a part of our lecture series, sir. And
thank you for inviting me, and all the best wishes to all those applicants who are appearing in the Advocate on Record examination. And I wish them all the best wishes. I hope that whatever I explained about anti-defection law could be of some use to them.
it's very helpful, sir. You also learned a lot.
Thank you.
Thank you,
Thank you
sir.
so much. Thank you. Good day.
Thank you, sir.